Good afternoon. My name is Alana Odoms. I am the Executive Director of the ACLU of Louisiana. Thank you. First Black woman in our organization's 70-year history to hold this role. And you all might say that that's Black girl magic, but what I want to draw your attention to is Director Counsel Janae Nelson and the Black woman work that it took to deliver those arguments in the way that she did. We salute you, sister. We are proud of you. Thurgood Marshall and all of the Director Councils are standing and watching and honoring you. And standing here on these steps, I'm reminded of something. I'm reminded of Dr. Martin Luther King's words from the March on Washington, that when the architects of our republic, the Constitution and the Declaration of Independence, they were signing a promissory note to which every American would fall heir. It was a promise that all people, Black and white, brown, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. And voting being the most sacred of all of our rights as Americans. But Dr. King told us that America had defaulted on that promise and that the check-marked justice had come back stamped insufficient funds. And so here we are again, generations later, still asking the same question. When will this country make good on what it put down on paper? That question was the question that Oliver Brown asked 70 years ago in Brown versus Board of Education. And it is the same question that the Robinson plaintiffs are asking today in Calais versus Louisiana. This case is as seismic as Brown, because just as Brown tested whether America would dismantle the legal framework of segregation, Calais will test whether we will protect the political power of Black Americans and communities of color, or allow the inertia of discrimination to pull us backward. My grandmother, Sally Georgiana Odoms, was born in Newport News, Virginia, just about 20 miles outside of Jamestown in 1930. She came of age under Jim Crow, when discrimination and racial segregation were not just social norms, they were the law. The inertia of discrimination was built into the system itself. Power kept it running. Only resistance could interrupt its motion. That inertia didn't end with Jim Crow, though. It simply evolved. Today it hides behind new names, voter integrity, a colorblind constitution, partisan gerrymandering. Yet we all know what this case is about. It is about racial gerrymandering. And we know that voter suppression continues to live on in the state of Louisiana, all across the American South and across this nation. The tools have changed, my friends, but the intent has not. To dilute the political power of Black communities and communities of color, and to maintain the imbalance of representation. That is what Section 2 of the Voting Rights Act was designed to prevent. It doesn't ask what's in someone's heart. Again, as Justice Jackson brilliantly argued, it doesn't ask about discriminatory purpose. It looks at the effect. And the effect in Louisiana is clear. The old maps denied Black voters an equal voice. And when a fair map was created at last, giving Black voters a second opportunity district in a state that is 1/3 Black, what happened? A group of white residents sued, calling it violation of the Equal Protection Clause. Now the Supreme Court is determining and answering a dangerous question: whether remedying racial discrimination violates the Constitution itself. This is not neutrality. This is the inertia of discrimination dressed up as equality. I have the privilege to represent the beautiful state of Louisiana. It is a state of contradiction and yet of deep courage. The birthplace of Plessy versus Ferguson, but also of resistance. The Baton Rouge bus boycotts that inspired Dr. King himself in Montgomery. In my work with the ACLU, I often think about the sons and daughters of our movement. Dr. Ronnie Moore, now some 80 years old, the son of Louisiana, he was a member and founding member of the Congress on Racial Equality, a hero of our civil rights movement who risked his life registering voters. Dr. Ronnie is famous for these words: you have to know what time it is. And my friends, we know what time it is. It's time to march, not retreat. It's time to resist the inertia of discrimination that tells us to stand still. It's time to resist the powers that tell us to sit down when we know we must stand up and fight back. It's time to defend the Constitution, not just for minorities, communities, but for all people. This is what we must do. The law, I believe the law at its best is an act of love. A promise that we belong to one another and that every voice matters. But love, like justice, requires motion. We can't stand still. It requires us to push against the inertia of discrimination that would hold us in place. This case will show whether we remain a nation becoming or a nation retreating. My grandmother knew what time it was. Dr. Ronnie knows what time it is. And I know what time it is. Do you know what time it is? If you know what time it is, then say it's time to move. Say it with love.